guys, and welcome to my channel. My name is Diana Romanovska and I am a family law specialist practicing family law in San Francisco and in Marin. Today I would like to talk about custody rights and what to do if you would like to file for custody. Magic of editing. Now that you met my daughter Anastasia, I'm going to go into basics before you think about filing for sole custody. A lot of people are asking me nowadays in COVID-19 times, I want to have sole custody of my daughter, of my child, of my son, and without knowing how court looks at it and how the law sees this. So, first of all, in order for the court to have jurisdiction, meaning in order for the judge to have the authority to even decide about a particular child, the child needs to live in California, in the state, for at least 6 consecutive months. And the parent who is bringing the action needs to continue to live in California. So that's number one requirement. Second, and I'm going to give you some code sections. So the jurisdiction code section is Family Code Section 3421, and you can look it up on your own later. Now, the court looks at two things: physical custody and legal custody. Physical joint custody is defined in Code Section 3003, and physical custody and legal custody is decided in Code Section 3007. So the difference between two, as the word physical suggests, where the child physically resides primarily. It is important for the address where the child lives. For example, registering to school, it's important to know. Legal custody is defined who makes the most important decisions, such as doctor, religion, and even posting on social media for the purposes of having advertisement for one parent's business also is an important decision. And so when the court awards joint legal custody, both parents have to mutually agree to child's important decisions before making them, not after. So what does the court typically does? Typically the court awards to one parent physical custody where the child primarily lives, and then to both parent joint legal custody. It is presumed to be in best interest of a child for the purposes of frequent and continuing contact to both parents, free from domestic abuse, free from violence. In one important case called La Musga, the court decided to award custody, sole legal and physical custody to father when and if mother moves to out of state. And the court concluded, based on child custody evaluation, that it would be in best interest of a child to stay with dad. So also a quick note, since January 1st, 2014, legislature said that it is also possible to have more than two parents if it preserves emotional bond and preserving pattern of care, meaning if the third parent was there all along, then it is considered to be in the best interest of a child. Now let's talk about abuse. And a lot of people want to have sole legal custody, and that's not really what legislature and court allow to do unless there is credible abuse. I have so many cases where people make up abuse where there is none. However, it has to be credible abuse, and abuse could be physical, could be emotional. And I can go about definition and all of that in a different video. The court presumes that it is not in the best interest of a child to have perpetrator have joint legal and physical custody with the victim. And perpetrator is usually one person, one parent, and the victim is another parent, and the child is in between of abuse. So it's called 3044 presumption. The reason for that is because family code section 3044 defines the presumption, and I suggest you read it on your own as well. And in a case of an abuse, the court awards temporary custody to the victim and sole legal and physical custody to the victim, not to the perpetrator. So to overcome this presumption, the perpetrator has to go through different programs, potentially battery intervention programs, which is part of 52 weeks, part of domestic violence restraining orders. Could be 12 weeks in-person parenting program. Kids Turn is a very good program. Kids Turn program is usually what courts recommend. And another type of communication between two parents, if there is domestic violence and both parents cannot contact each other, but they do have to exchange in visitation, the court states that both parents can communicate. It's an exception to peaceful contact about visitation, and the communication occurs via ourfamilywizard.com. So those are pretty much the basics for child custody and visitation rights for you to know. I hope that was helpful, and I will see you soon. Bye!